The High Court there today adjourned trial of alleged husband killer Maryam Sanda to April the 19th to enable the prosecution call his first witness. Ms. Sanda's counsel, Mr. Joseph Daudu, has made an application for the charges against her to be dismissed on the grounds that it is incompetent, null and void. Mr. Daudu had argued that the charges, which were filed as an originating summons, ought to have been filed by the Attorney General of the Federation and not the police. He also argued that the police had failed to file the charges through first information. But the police prosecutor asked the court to reject the application of the defendant because it is misconceived. He argued that the Administration of Criminal Justice Act is the only operational law in the FCT and that the police had adhered to laid down procedures for filing a criminal charge.
The charge has not been filed by the proper person. It should have been filed by the Attorney General. The police filed it. Secondly, it was filed by way of charge, not information. Information is different from the charge. And therefore, there are so many defects that makes it that there was no charge at all.
The defense, in their wisdom, felt, well, the charge before the court is defective. And we're saying no. The charge before the court is proper and in conformity with the provisions of the law. And that is exactly our position. We have argued the matter, and it will appear that that is just it. Because the only procedural rule with regards to trial of criminal matters in FCT is the Administration of Criminal Justice Act of 2015. And anything outside it is not known to us. And we have complied strictly with the provisions.